defense lawyer. Oh, there we go. Okay, recording. She's a senior defense lawyer that has a lot of experience, and this is for our third and last trilogy, dealing with the after effects of after a trial, after there's like a conviction or after a plea. And we wanted to talk about the things with sentencing. So kind of, I had already gone over this with Antonietta, but the kind of overview is going to be, oh, and sorry, I'm Tanya Kent. I don't know if there's some people that maybe don't know. And I'm a criminal defense lawyer in Toronto. So yes, just for the people outside of my little circle. And so the agenda for today, we're going to be focusing on preparation for sentencing and what the things that you should be doing, sentencing principles and what those principles mean, and how to intertwine those into submissions, our GLADU factors, important cases, how to deal with this, when and how to get a GLADU report, how to use that report, new tools that we have now for sentencing, including enhanced sentencing reports, and as well as important things to know in regards to ancillary orders, which are like prohibitions or SWIRA or conditions on a sentence that outside of the sentence that can actually affect your life, which should be considered. So Antonietta, I think that covers it, Antonietta, and we can start. So maybe it depends, we can just either go for a format where I just kind of ask you questions, or and then you can expand on things and we can go from there.
Whatever you'd like to do. I've got my written thing all ready to go. So if you're asking me questions out of order.
No, I'm not. I'm
gonna kill you. Sorry.
No, not out of order. That's in that order. So in regards to preparation for sentencing, so some of these things include support letters, PSRs, and counseling or volunteer work. So maybe Antonietta, you can give us an idea of kind of support letters, who to get them from, what's acceptable, what isn't, PSRs. Do we want them? How to prepare all those, and counseling volunteer, when do we have the client do this, how to find those resources?
So let's take it from the premise that the person has been either found guilty or has pled guilty. So now you're at a point where the client is now in your hands. Essentially the ball, like up until now, your client has simply been the accused person. They are the accused to the crown, they're accused to the judge. So your job as counsel, and it's a really big job, it's certainly not one that should ever be considered less important than anything else you do, is to make your client a real person with strengths, weaknesses, foibles, and the character and personality that they are. You have to make them real to the court. So one of the ways you can do that is through support letters. And where do you get support letters from? If your client's employed, I am a big fan of employer letters. Especially, and this is a big deal, obviously, if the client has told their employer, obviously that's the first part. If the client is concerned about telling their employer about what has happened and the fact that there is this guilty plea, then it's something that you would have to make a decision on. However, if the employer is prepared to provide one and your client's prepared to disclose to them that this is what's going on, employer letters to me are extremely effective, because it speaks to not only the fact that your client is employed and for how long and in what capacity, but that the employer has a connection to your client, and that your client isn't just someone who's committed this offense. They are a contributing member of this employment, and they get paid for it, and they have responsibilities that they meet, etc. It speaks to them as an individual. Family letters. Some people, some lawyers don't like family letters. Me, I will ask for as many letters from anybody that my client thinks will be able to give a thoughtful expression, to who my client is. One of the biggest things that you have to do with any letter of reference is you have to vet it. At the end of the day, while I appreciate that I'm getting letters from people and they want to express what they want to express, I take control of the letter. Once it's in my possession, if I have to cut anything from it or remove anything that would not be supportive of my client, I will. When I say that, what I mean is if the person is speaking about the offense itself, or if the person is speaking about, explaining that perhaps the client is, wasn't their fault or something to that effect, that should not be in a letter. Because at the end of the day, if your client has chosen to plead guilty, they have taken responsibility and are now being held accountable. So it's not, it's either your client admits and is fully accountable or they're not. There is no in between. If your client volunteers for any organizations or has any connection to any organizations that they provide support for, I would get confirmation of that. When it comes to something along the lines of counseling or treatment or anything that is being considered for the client to do in support of sentencing. So let's consider that counseling and treatment, it's a mitigating factor. So what I do is it's part of my plan, especially if we're talking guilty plea resolution track for a matter. That's a consideration that I'm thinking about right in the beginning and is likely to have been a part of a conversation with the Crown if it's part of the sentencing proposals that are going to be put to a court, especially if it's a joint sentencing position that's contingent on certain things happening. Having said that, if there is any opportunity or if there is something that counseling or treatment will provide to my client that will enhance their ability to ask for a lesser sentence, I will tell my client to do it. I'm not going to lie to you. When I speak to my clients, I tell them straight out from the beginning, if I tell you to do something, you're going to do it. Because I'm telling you to do it as it will assist you. You may not feel like you need it. You may not want to do it. But in the end, if it's going to assist the sentence in obtaining the sentence that I am looking to obtain for you, then you're going to do what I'm asking you to do. I've never had any challenges from my clients. At the end of the day, we're in a very unique position, I find, as criminal lawyers, because unlike other areas of law, I practice in family law, for example, or other areas, the lawyers tend to be more in a position where you have to take instruction from your client because it's about what they want and the outcome that they're looking for. I find in criminal law, obviously you take instruction from your client, but most clients, they're looking to you to guide them. They're not really looking to you to ask them what they want. Like, what are you prepared to do? What do you want to do? What do you think you can do? They're looking to you to guide them to where they believe you will be able to obtain the best outcome for them. So it's a big responsibility. If your clients are or have already been under the care of a psychiatrist or therapist or anyone else, information from those people. Again, I have the ability to vet and determine if it's something that will assist my client or not. And if it's not, I don't provide it to the Crown or to the court. Real quick example, I have a client right now. She's got charges all over the GTA, many different courthouses. She has a very tragic background. So in my, it's my belief, and the Crown actually agrees with me that there are issues that she suffers from. There are things that she has to deal with, and that it may be informing the offending that she's engaging in. So as I go along in trying to figure out all these charges, I've already gotten in contact with a psychiatrist that she's seeing, and her family doctor and any other counselors I've already obtained. So when you're dealing with those individuals, you do have to remember that they have confidentiality issues. So you're going to have to prepare a direction, an authorization and direction from your client that will allow you to obtain that information from those individuals. So I have a bunch of them for this particular client, and I'm working on getting as much information and or reports for my client, even at the stage where we're not necessarily, you know, she hasn't necessarily pled guilty, but I'm hoping it will inform whatever resolution we can come up with. I had a client once tell me, well, what if I get a letter from a local politician? Excuse me, my allergies are running amok right now. I'm sorry. Or you know, what if I get a letter from, you know, someone who's in the community, but that doesn't know your client? To my mind, it doesn't benefit your client at all. At the end of the day, what you want is you want information. You want as much information as possible to support your client as an individual, to make them a real person. And ultimately, you want whatever it is that you're getting to connect with and to become a mitigating factor for your client, okay? Because that will ultimately inform the judge's decision on sentence. PSRs. I'm honestly, I'm not a big fan of pre-sentence reports. The reason for that is I think I'm well equipped to do what a probation officer does, and I have control over the information that I am going to be providing to the court, which is to say, I'm not misleading or lying to the court, but PSRs, I've had experiences where the probation officer, so it could be requested by the Crown or defense, and it will be ordered by, or it could be ordered by a judge, but it has to be ordered by a judge. It's prepared by a probation officer, and it usually takes anywhere between 2 to 6 weeks to prepare. The thing is, a probation officer will be speaking to your client without you there. Probation officer will be speaking to their family, friends, or employer without your client or you there. And there's always, to me, a risk of misunderstanding, miscommunication, misinterpretation. I had a client that we sent for a pre-sentence report, and I ended up having to get a further report from my client's doctor because the probation officer honestly didn't, it was the way my client described it was the probation officer was quite aggressive and confrontational, and you never know who you're going to get, and you also never know how they're going to ultimately interpret the information that they're getting, because what they also do is they will make recommendations with respect to the probation terms. And I have, in my experience, 18 years, seen probation officers indicate where they see fit that, you know, we don't think, you know, while probation, we can certainly put on probation terms, we don't think it's going to help. You know, custody is probably preferable. And I don't need first off, as far as I'm concerned, that's outside of their purview. But secondly, it does color something, and it colors the circumstances. So I'm not disparaging probation officers or PSRs, but I prefer to do the work myself. I'm also someone who knows my client, and I have a unique perspective on my client outside of employers, et cetera, or their friends and family. I've been dealing with this person for quite a while, and I think I'm in a better position to extol not only the virtues, but express the client's remorse or their understanding of what they did was wrong, etc., than a probation officer could. That being said, there are other tools that are beyond, I think, our scope, and I will get to that eventually, would be GLADU and enhanced GLADU reports and enhanced pre-sentence reports for our clients. Counseling volunteer work is always something that can be done by your clients. If sentencing has been put off for the purposes of a client doing work, upfront work, which is what we usually call it, it's a matter of just having that time. I also find that if that's something that you're going to be doing, the court will give you that time. The Crown will give you that time, or more specifically, the judge, especially if, you know, you have, if you're running into any resistance at the end of the day, what I find is as long as I have some information about, you know, my client's line in the queue or how long the process is going to take, or if there are any interruptions there, the court is very amenable to that. In terms of finding those particular places, when it comes to counseling specifically for your client on a one-to-one basis, it can be quite tricky, as we know, because counseling is expensive. If you are talking about a psychologist or you know, a private therapist. I do have a client that I was assisting, and in terms of, for example, obtaining a psychiatric assessment, my client attended Sound Times. Okay, so Sound Times is a resource center where people with mental health and substance abuse require assistance with housing and other issues through Sound Times, where you have an order, perhaps in a more likely, most likely in a bail or their release from custody. If there's an order that the individual needs to get a psychiatric assessment, it can be done through Sound Times, and there is no cost to the client, provided they, you know, they can meet the financial eligibility. There are other resources as well. What I often do, frankly, is I will call places that I have experience with, and I will simply ask them, do you know of any places that I might be able to get this done or that done? In terms of a client I had recently, there is now, for example, some people do, some people don't know, but there's an alternative to the PAR program. And it doesn't require you to be admitted. It doesn't require any kind of bail variation. It's through a program called Just for Today. And that's run through the University of Toronto Faculty of Medicine, which to my mind actually carries a significant amount of weight. And I've never had any trouble with them in terms of being accepted. They also offer couples counseling as well as other individual counseling. I had a client where I was able to obtain a conditional discharge in a situation where there were injuries in a domestic. In that case, the victim was supportive. So they wanted to get back together. It was his wife. But in that circumstance, I had the client do the 12-week domestic violence counseling. It's similar to the PARS program. I asked the two of them to do couples counseling. We had a bail variation that allowed them to be together at that point. And I also got them to do individual counseling because they have a child that was present. And there was some suggestion that, you know, my client's aggression, you know, needed to be stymied even with the child. So we got that done. So the reality is the resources are out there, and I also will ask for resources through the WiCCD website. I apologize if I don't have more than I can offer you, but I can say too that I have my own roster of individuals that I will look to for help when it comes to, let's say, counseling, if your client's charged with assaulting their kids or something like that. If anybody ever needs, just let me know.
And I think also that maybe because everybody's from different provinces and stuff, I think also maybe it could be something that we do as I don't want to put work on anybody, but a WiCCD project where we have some resources located in different provinces or different cities. Because something like Sound Times is actually based in Toronto, but there might be something that goes by a different name elsewhere. So that might be something that we could look into doing, is having those resources kind of in maybe a list or something that we can access for our clients, so that it's a bit more Canada-wide and accessible for people, if that's something we can do.
That would be great. And listen, Tanya, please, if I'm going on, just shut me down.
Okay. So the next point we can deal with is sentencing principles. So these are the principles that every judge has to look at when thinking about a sentence. So such as general deterrence, specific deterrence, rehabilitation. So maybe we can shortly touch on those and how to intertwine those into your submissions.
Absolutely. My starting point generally also, I think it's important, is when whatever your charge is, like your client has pleaded guilty, let's say, to possession of child pornography. For me, a starting point is always to know what the main sentencing principles are for a specific offense. Because as we know, the courts have determined, depending on the type of offense, that there are certain sentencing principles that have to be addressed. Like they are the main principles that must be addressed, and then we can look at other things. So for example, in terms of possession of child pornography, it's general deterrence and specific deterrence and denunciation. So those are, that is your main hurdle. And then, you can focus on other things, but you have to understand that in terms of that particular offense, that is going to be the main focus of the court. So you have to not only speak to that issue, you not only want to speak to rehabilitation, etc., but you have to do that. So that's usually a starting point for me. How all of this factors into GLADU and the enhanced sentencing reports we'll get to later. But as we all know, the main principle of sentencing is proportionality, which is the sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender. There are two parts to that. The court will look to the potential penalty and features of the case that would increase or decrease the harm or risk of harm to the community. So how serious is the offense? What was the harm that was suffered, or what risk of harm was, put to the community? Someone, for example, who is driving impaired on a highway in the opposite direction of traffic. That's a pretty, the gravity of that offense, especially if you have an accident, or sorry, there's a collision of some kind and someone's injured, like the gravity of the offense increases. The other part of proportionality is the degree of responsibility of the offender. So what is their moral blameworthiness? It's at that point that the court will consider the background and the behavior of your client in terms of how that increases or decreases their moral blameworthiness in committing the offense. If I can just introduce right here for a moment, when we're talking about, for example, enhanced pre-sentence reports as it relates to Black, Indigenous, people of color, specifically Black offenders, okay? And I would like to say, as the white lawyer speaking, I am by no means someone who is, the most informed person, but I'm going to do my best. But I want to say that the case of R.V. Morris from the Ontario Court of Appeal, the court made it very clear. They did not accept that Black or people of color, Black offenders or people of color who are offenders, that they ought to receive or should be subject to the same considerations as Indigenous offenders, such that it rises to the level of a GLADU. They are required in respect of any Indigenous offender. That did not happen. However, with respect to the use of those enhanced pre-sentence reports, what the court did say is when that information becomes relevant, it's not relevant at the issue of the gravity of the offense. So how serious it is, the risk that is put to the community, and the court used situations, let's say, of an individual with, in possession of a firearm in a community or in the commission of an offense. However, where it does come in and factor into how, when it factors into sentencing, it will and absolutely is relevant to the issue of the degree of responsibility of the offender with respect to their moral blameworthiness and frankly, what got them there, okay? Other factors, other principles are parity. A sentence imposed for an offender should be similar to offenses committed by similar offenders. So that's why we do all that lovely case law searching, trying to find cases that are similar in type of offense and, you know, offender backgrounds like criminal record, no criminal record, etc. The totality principle, forgive me because I don't remember the case. I know it came out, and I know it came out before the sentencing of the individual who killed all the people on Yonge Street. Jesus, I can't remember. My brain is dying. However, the idea that the totality principle is such that when a court imposes consecutive sentences, the principle of totality requires the court to ensure that the total combined sentence is just and appropriate. Okay, so totality deals with consecutive sentences. Restraint. It's relevant to cases where imprisonment can be used as a punishment. It is a principle that is very important in response to over-incarceration, where the court has to consider other punishments that can serve to restore the person to the community. So the principle of restraint requires
little, very little, but it is a.
Sorry, the principle of restraint requires, you know, a jail to be used only if no other punishment or combination of punishments is appropriate to the offense and the offender. Retribution. Retribution is not vengeance. It speaks more about accountability. So retribution is meant to be a measured punishment to reflect the moral blameworthiness of the person. So of course, the higher the moral blameworthiness, then in that circumstance, then the likelihood of a greater punishment versus someone whose moral blameworthiness is less. Retribution is meant to deal with that particular issue of that person's blameworthiness. Denunciation. So denunciation is about how do we basically yell to society that we are not condoning this behavior and this is what we're doing so as not to condone this behavior. Just as a really quick story, I was once in court and we were dealing with a sentence for a client and there was nobody in the courtroom. And so of course the Crown is going on and on about denunciation in general deterrence. And I'm like, Your Honor, we speak very, you know, eloquently. The Crown always speaks very eloquently about deterrence and denunciation. But I got to ask you a question, you know, who in this courtroom is going to be deterred? What exactly are we denouncing to whom? There's nobody in the courtroom. Who's going to read this case? Are you planning on writing it and putting it onto LexisNexis? And if you do, is it you know, generally available to the courts, to the society? I've only ever done that once, and it was just out of frustration because the Crown kept going on and on and on. But I had a moment there where I thought, well, I appreciate this particular, I certainly appreciate these particular principles. It's important to consider, to my mind anyway, it might be worth, depending on the situation, the circumstance, finding a way to undermine that particular principle, specifically denunciation. Having said that, when you have serious offenses, so, you know, possession of child pornography or, you know, violent offenses, domestic violence, where it rises to the level of some very dire consequences, deterrence and denunciation are important factors because of the fact that these are issues that society grapples with daily, and they are things that you know, we are trying to curb as a general society, but we always seem to be 10 steps behind. Incapacitation. This is an important thing that we don't often look at, but it's certainly a principle that relates more so when you're dealing with dangerous offenders or offenders who can't be deterred from committing further offenses, and where there is significant evidence that they can't be reformed. So to me, it's like incapacitation and separation are intertwined in that way. Rehabilitation, we all know, is a very, very, very important principle of sentencing. there's always the possibility of rehabilitation, in my opinion. Any stone that can be turned must be turned to try and convince a court that rehabilitation is available, because if we don't have hope, we have nothing. And one of the relatively newer concepts, but again, this connects to some of the issues, some of the, in terms of, let's say, GLADU or the enhanced sentencing, pre-sentencing reports, is the idea of restoration. The idea that the problems, the consequences of a crime can be addressed, or the needs of the consequences of a crime can be addressed in terms of the needs of all the people involved in the offense, including the offender, the victim, and the greater community. So restoration deals with restorative justice and how we can potentially, depending on the circumstances, allow for a more communal approach to addressing sentencing with respect to a particular offender and a particular victim. Does anybody have any questions? Or Tanya, is anything you want to say?
No. I think we can move into the GLADU factors and maybe
Awesome.
just talk about the importance of making sure, I guess, at the beginning of a file, understanding that exists, because it obviously is the first thing at bail is also considered. But we're talking about it in the sense of now someone's pled guilty or they're being sentenced. So because I think a lot of people aren't familiar with getting reports or and how important this is and how to deal with this.
So I once read, I think it was last year, an article where the ability to obtain GLADU reports depends essentially on where you are and what the resources are that are available to you. And sometimes it depends on the Crown, because again, although I practice in Toronto, I was I started out as a prosecutor. So I was working in Kingston, Belleville, Napanee, Peterborough, Lindsay. These are small jurisdictions. And that's not to say that, people were resistant to the GLADU reports or not, but it often depended on what was available, who was going to be able to do this, because first and foremost, GLADU reports are prepared by an Indigenous individual. The report itself, first and foremost, is meant to provide background and information about an offender, an individual. So the individual who's pleaded guilty, and it's meant to support non-jail or lower custodial sentences depending on the circumstances. So what are the individual factors and intergenerational and historical factors or dysfunction or struggles that have impacted this person? And first off, it's mandatory it's a mandatory duty on a sentencing court, okay, to consider the unique situation of this person. So to my mind, when they say it's mandatory, this is not the kind of thing that happens. It's not just a minor reflection on an individual's background. This requires some real historical and individual contemplation by someone who understands and is part of, I feel, that cultural community. So I would like to say, just in terms of cases, obviously there's GLADU. There's also the case of IPELEE, IPELEE. So I don't have the citation. There's a good case called McIntyre Surrett. That's MACINTYRE-SYRETTE, 2018 ONCA 259, it's Court of Appeal case. And I did come across two cases that I thought were brilliant, frankly. The outcomes weren't the outcome in one was better than the outcome of another. And this both cases were argued and represented the individual was Shauna Kelly. And the first one is RV Armitage, RMITAGE, 2015 ONCJ 64. And that was a case by Justice Nakatsuru, who I have to be honest with you is like my hero now. It was Justice Nakatsuru who also decided the cases of Morris, and I apologize, I forget the other case, that really forced the idea of enhanced pre-sentence reports through the court system after counsel tried to do it through Justice Nakatsuru. And the other case is RV Francis Sims, FRANCIS -SIMMS 2017 ONCJ 402. I'd really like it if anybody could take a moment to read Armitage, because Justice Nakatsuru started the decision by saying, you know, we usually write these cases for lawyers, judges, whoever's going to be reading them to use them eventually one day. And he said, I'm writing this one for Mr. Armitage. And it was written in plain language, very straightforward and incredibly thoughtful and just aware of his audience. So I thought that was great. Anyway, essentially the report, you ask the court for a report. You tell the court that upon sentencing, it's mandatory that the court must consider the unique situation of your client as an Aboriginal offender, and therefore a GLADU report is required. We are seeking it. If you don't ask for it, I have found that judges generally just come up with it on their own. I have not experienced too many times a Crown objecting, but I have had some Crowns attempts to object by saying, well, you know, even though it's mandatory to obtain this information and to understand the unique situation, we don't really need a report for that. And to my mind, again, my argument would be, well, where else or how else are you going to get it? You may run into circumstances where they are harder to obtain within a certain period of time. Because GLADU reports are so much more thoughtful and in-depth and laden with information that takes time to obtain. And sometimes it's more difficult to obtain, perhaps because, you know, the client may not have as direct contact, may not be in direct contact with individuals or have a lot of relationships. It could take more time. They're also more expensive than pre-sentence reports. So they're not the easiest to obtain, but depending on where you are, they can be facilitated much more easily. You know, the GLADU court at Old City Hall is it's light years away from, you know, when I was in Peterborough. It didn't happen often. And, you know, if you did get a GLADU report, you'd have to scramble around to find out who was going to be able to get that and how long was it going to take. So their availability exists. It seemed, from what I can tell, provinces such as Manitoba, Saskatchewan, Alberta, from what I understand, I could be wrong, but the processes there are more streamlined and there's more available. Ontario is lagging behind in many ways, and I think that more could be done, and it needs to be better, but that's about all I can say on that point. The use of the report is essentially pretty straightforward, but you cannot underestimate its value. So ultimately, because one of the most important benefits that you don't see in the criminal justice system or by the criminal justice system is the therapeutic process that it can, or the therapeutic impact it can have for your client. Many Aboriginal offenders have not been provided an opportunity to explain who they are and have never had an opportunity to self-reflect on how they've become who they are. And that report can provide for that self-reflection. It also can help them in identifying and connecting them with a larger community that they may have been either by force or by choice or simply by circumstance not connected to. And the individual who is doing, so the GLADU caseworker is Aboriginal, as far as I understand it, and that's been my experience. And they are also able to assure your client that there are resources and supports available to assist them in dealing with a lot of these issues outside of, if your client has substance abuse issues or mental health issues or other types of issues, those may be, likely are, connected to these other historical and systemic issues that they and their people have suffered throughout centuries. So practically speaking, GLADU reports are usually ordered when the Crown is seeking jail sentence. Some organizations will only write a GLADU report if your client is looking at a jail sentence of 90 days or more. Some organizations might write a GLADU letter, not a report, a letter, if the Crown is seeking a jail sentence of 90 days or less. There are organizations that you can contact to consider getting these GLADU letters. And as far as I'm concerned, similar to what I said in the beginning, it's your responsibility to make sure that anything and everything that you can assist your client in doing to obtain the best outcome, best sentence possible for them, this is part of your job.
And I just wanted to touch on as well the new tool, because although GLADU is something that's been around for some time, tools that we have for sentencing, including discussing, I believe it's Emily Lamb and Anthony Morgan started it, two lawyers here in Ontario, for the Sentencing and Parole Project, and they are the ones that do the enhanced sentencing reports. And I believe they're specifically for Black people. I'm not sure if they include other people of color, but I think just for Black people. So if you can speak on those reports or how I know how we get them, but if you speak about how we get them.
Yeah, so the way that, to my mind, again, so the Court of Appeal didn't make them mandatory. It's pretty clear about that. But in my reading of Morris, so this is R.V. Morris, the Ontario Court of Appeal in 2021. I think it came out in February. My impression was the court did say, listen, first off, well, one of the most important things that they said, and I think this is something that you have to take to understand, that what they were saying was, we have to address this. But the way that, let's say, Justice Nakatsuru addressed it wasn't the appropriate way, meaning it doesn't diminish the gravity of the offense. However, it does speak specifically to the individual's moral blameworthiness. So in the end, this person. So to my mind, and listening to the Court of Appeal, as far as I can tell, what I took from them was, we have an obligation to bring this information to the court. We have an obligation, if anything close to what would purport to suggest that there's an impact of systemic racism with respect to your client, then enhanced pre-sentence reports ought to be part and parcel of the evidence that's provided to the court. The Court of Appeal also acknowledged that these reports are accepted. They did have a bit of an issue with respect to the person who prepared the report, insofar as that individual was commenting on the mental health, more clinically speaking, of the individual, and they thought, well, that's a bit overstepping. You're not a medical doctor, or you're not a therapist, psychiatrist. But in respect of your client's background and the societal circumstances within which your client has grown up, and their family members and their close and other close individuals who they will speak to. So this would be, a clinical or an experienced social worker. The idea is to provide this background for culturally, so ultimately, and they will make recommendations for culturally appropriate community-based rehabilitation programs. So it will also provide a personal history of your client, connecting specific biographical information with research and data about the impact of anti-Black racism. So if you have a client and the client, and the offense, it's a consideration like anything else, right? If your client's being sentenced for theft under and, they have a history, but, the Crown's going to give you, and they have a record and the Crown's prepared to suggest a suspended sentence and the evidence is pretty bad, you take it, right? It is what it is, depending on the circumstances, to be clear. But where you're looking at situations where you have custodial sentences and the impact on your client would be to essentially stymie the rest of their life or potentially impact what comes next, which is what will happen, because as we know, incarceration is really, the most impressive means of rehabilitation that I've ever seen, or reintegration into, productive reintegration into society. That's what jail does for you. But in the end, if there is even a minuscule opportunity for this report to provide a benefit to your client, then you ask for it. And you tell the court it's your intention to obtain one. You will be obtaining one. You'd like the court to order one. And you ask for the time to do it. You would then, and then you would contact the Sentencing and Parole Project.
Yeah, I was just going to say, and I think you have to leave enough time, because I think that the issue with the project, not really an issue, but more of a funding thing, they have very limited resources in regards to social workers and things like that. So it's hard to get. I think the list is like almost like a year. I think it was like 8 months to a year long is the last I heard of getting them. So it can be a lengthy time. So if your client is facing serious time, it might be worth it waiting, because they're gathering the dead time anyways.
Exactly. Like if they're in custody, it's those are the issues that you're also balancing one way or the other. So yeah.
Exactly. And so the last focus we want to take in our time is important things to know in regards to ancillary orders. So that includes like weapon prohibitions, SPIRA, which is a sex offender registry, and conditions that you should consider. Those types of ancillary orders you should consider that affect your client's life.
Absolutely. So obviously, depending on the type of offense that your client has been convicted of, different ancillary orders will come up. So aggravated assault conviction, your client is going to be subject to a mandatory firearms prohibition under Section 109 of the Criminal Code. Assault, your client could be subject to a firearms prohibition under Section 110 of the code. Now, if that's part and parcel of your conversation with the Crown and they're like, well, we want a 110 order for 2 years, that's up to you. But it's not mandatory, it's discretionary. The Sex Offender Registry, the Sex Offender Information Registration Act registry is, of course, when someone is convicted of an offense that's enumerated under the code, anything sexual related, essentially, they will be registered onto SWORA. Depending on the type of offense and whether the Crown proceeded by indictment or summary conviction, the length of time that your client will be on the registry is dependent on that. If your client is convicted of sexual offenses, you're also looking at orders under Section 161 of the code. Those orders can prohibit your client from attending a swimming pool or a public place where children will be or may be. That also includes, for example, restrictions on your client being able to use a computer in terms of if your client's been convicted of possession or otherwise of child pornography. So that's definitely a term to consider. I had a client who was a computer guy. That was his employment. And he was convicted of possession of child pornography. So the order was that he was prohibited from using a computer and other types of devices unless he was using it for work, and that was information that had to be arranged with his employer. Other orders can include firearms forfeiture orders, depending on what your client is convicted of. Forfeiture or return of property obtained by crime. So clients convicted of an offense where it's alleged that they have in their possession, or they continue to have in their possession, or they have property obtained by crime, while a forfeiture order can be ordered. Forfeiture of proceeds of crime. Your client's convicted of, distribution of narcotics, and, that when the police attend their house, they find jewelry and whatever else they find, and they seize. And then there's an order for forfeiture, provided they can connect it to the crime as being proceeds. Computer-related property for online child porn exploitation, that can be forfeited as an order under section 164.2. The forfeiture orders I was just talking about, they're in the section 491, 462, and 490 areas. Forfeiture of counterfeit items. You have fake money, they're not going to let you keep the fake money. I didn't know this one existed. Forfeiture of valuable minerals. I guess if you steal valuable minerals, they can forfeit it. You can also be fined in lieu of a forfeiture. So if there's an issue with the forfeiture, you can be fined for it. There are also restitution orders. So your client stole $500,000 from their employer. This can be made a standalone order, as opposed to being a compensatory order. It used to be something that judges used to do, but they can't do that anymore. It was a long time ago. So it's a standalone order under section 7. It can be ordered as a condition of probation, section 7032. It can be ordered as a condition of a conditional sentence, or as a standalone order under section 738. You have to remember there's a difference between restitution and compensation. And we don't generally, I don't see a lot of compensation orders, but restitution orders I see. Restitution orders can be ordered by the Crown, can be sought by the Crown and ordered by a judge. I have found that depending on the amount of the restitution that needs to be made, they're made, but consistently following up with something like that is often difficult. And you have to make your client aware that if they don't pay it, it can be subject to some kind of further charge. Driving prohibition orders. I'm going to be quite honest with you. When I left the Crown, I stopped practicing an impaired driving law. So I'm going to leave it to you guys to do your own searches, because it's gotten so bloody complicated. I don't understand it. Then there's also, ultimately, you have to remember the victim fine surcharge. Where someone is convicted of a summary conviction offense, it's $100 for each summary conviction offense. For an indictable offense, it's $200 for each indictable offense, or 30% of any fine imposed. So if your client receives a $1,000 fine, and yes, I am using my calculator, they will be required to pay a $300 victim fine surcharge. Depending on the circumstances, sometimes you can, as far as I understand it, it's not mandatory, but I have found that it's not always remembered by the Crown. Judges usually do remember, and it's something you should definitely be prepared to make submissions on.
Okay. And so I think, well, it's right 2 o'clock right now. I don't know if anyone has any other questions for Antonietta about sentencing or about any of the things we discussed today. You can just pop out and ask, or throw it in the chat where we can see it.
Absolutely, you guys, feel free to call me anytime. May I say one thing? It wasn't in the excuse me, in your list, but there, keep in mind when you have a young offender, youthful offender, there are also section 34 reports, psychological reports that can be prepared when making a decision on sentencing for your young your youthful client. Okay. Those also contain recommendations. So something to keep in mind.
Thank you so much to Antonetta for being with us today. We really appreciate it. And I think that we learned a lot about the resources that are available, and also figured out a new idea that WiCCD could participate in regards to counseling resources across the country. And I think we've definitely covered a lot in our 1 hour. I was a little bit nervous, but we covered a lot in our 1 hour. So I'd just like to thank Antonetta for attending, and thank all of you for also attending the session today.
Listen, I'm going to tell you my notes. They're not bad, but they make sense. So if you want, I'm happy to send a copy of what I put together to Tanya, and if you all want it, like, it's got some of the cases that I cited, etc. But you're more than welcome to have it. And I don't take responsibility though for what's in it.
Yeah, no, that would be great, and then we can pass it on.
Absolutely.
One that can have it. We've also recorded the session as well, but also pass on those notes.
For sure, I will.
Okay,
it was wonderful. I really appreciate it. I love doing this. So if anybody ever wants to talk to me, by all means, I'm around.
Okay, yeah, and thank you to Salamatu and Hamna for, I think, hosting us.
I'm just attending.
Oh, okay. I just kept seeing your face there, but I know Salamatu was involved in putting it together. So thank